Hello and welcome to the webinar Competition Law, Internal Investigations and Compliance Training, In-House Counsel Experiences and Expectations from Outside Counsel. When corporate scandals hit, financial crises occur, or when tougher corporate accountability standards are enacted, internal investigations become an important exercise for good corporate governance. As a result, in-house counsel find themselves under new pressures when it comes to managing, advising, or assisting such investigations. Our session today will provide general counsel and investors with practical insight into the latest competition law internal investigation trends. My name is Haveen and I'm here from the Legal 500. We have a great panel of speakers with us today who will be sharing their expertise. Introducing them will be our moderator, Gernanz Gerkenack, founding partner and head of ELIG Gerkenack's Competition Law and Regulatory team. Gernanz received his LLM degree from Harvard Law School and is qualified to practice in New York, Brussels, England, and of course, Turkey. He has worked in many of those jurisdictions whilst a lawyer at a global law firm. In 2005, he founded his own firm, which has become a leading antitrust firm in Turkey. Gernanz has more than 20 years in competition law experience, starting with the establishment of the Turkish Competition Authority. In addition, he holds teaching positions at undergraduate and graduate levels at 2 universities and has published more than 150 articles in English and Turkish. These are just some of his achievements. Before I hand over the reins to him, for him to introduce our expert panel of speakers and get the session underway, I just wanted to give a special thanks to ELIG Gerkenack Attorneys at Law for sponsoring this webinar. I also just wanted to let the audience know that if you have any questions throughout the session, please feel free to write them in our Q&A chat boxes. Our panelists will be able to view them in real time. With that all being said, I will now hand over to our moderator. Thank you, Gernanz.
Thank you, Harveen. Much appreciated. And it's a humbling moment because when you're introduced as 20 years of competition law experience, that normally accounts for something, but in the presence of Anne and Joe, it's not even half the way as compared to what they have been doing. Anne Riley is currently the co-chair of the International Chamber of Commerce Antitrust Compliance and Advocacy Task Force, which is well known for its compliance toolkits, assisting companies to design their own compliance programs. Her last position before she retired was head of Royal Dutch Shell's global antitrust team and a member of Shell's global ethics and compliance leadership team in 2019. She is a non-governmental advisor to DG Comp for the work of the International Competition Network, the ICN. She is currently an independent ethics and compliance consultant, working primarily in a pro bono capacity for antitrust agencies. And then we also have Mr. Joseph Murphy. Joe Murphy is a senior advisor to compliance strategists. For over 40 years, Joe has been a tireless champion of compliance and ethics in organizations and has done compliance work on 6 continents. He did compliance work in-house for 20 years and co-founded a company that did online training. Joe has published over 100 articles and given over 200 presentations in 21 countries. He is the editor of SCCE's Compliance and Ethics Professional Magazine, has served on SCCE's board, and is SCCE's Director of Public Policy pro bono. Joe has been recognized with SCCE's Compliance and Ethics Award, received the Concurrence 2021 Antitrust Compliance Awards Special Award, and was named one of the National Law Journal's 50 Governance, Risk and Compliance Trailblazers and Pioneers. He was co-authors of a book, which happened to be the first book ever written on compliance. That's Sigler and Murphy. Most of you, if you have been familiar with the compliance field, will know interactive corporate compliance and alternative to regulatory compulsion. So without further ado, with the caliber of these 2 speakers, to make sure that we're using the 1-hour time that we have at hand most efficiently, I'd like to pose my first question or invitation for comments to Anne Riley. There are very many terms that are being used as if they are interchangeable. The reference to an internal investigation or an audit be it an announced or unannounced type of audit, or mock-down raid. So two questions hidden in one. One, what are your views on the concept of a mock-down raid? Do you feel that this is fair game in the realm of compliance efforts, or is it something to be avoided? Are there any negatives that you see, or do you feel that it's good and is useful? And also, how do you distinguish internal investigation as a term from the rest?
Okay, there are a number of questions in there. Yeah. Let me deal with mock-dawn raids first. First, let me acknowledge that views differ on the benefits and the pros and cons of mock-dawn raids. I'll put my cards on the table and say, personally, having actually done many of them in my 30 years, nearly 30 years at Shell, I am not in favour of them. I think there are many drawbacks to them, including drawbacks outside the straight antitrust legal field. So you've got to remember that there may be an emotional impact on employees, so you've got to be ready for that. It depends how the mock-dawn raid is done. If the mock-dawn raid is done like many external law firms like doing them with people dressed up as or pretending to be officials, I think it's very important to remember that impersonation of officials is actually a criminal offence in many countries. So that's another issue you've got to bear in mind. But I think my biggest complaint about them, if you like, is that the time that can be given to them is much better spent on doing a proper and thorough investigation using proper tools, because the risk of a mock-dawn raid, whilst it does, I guess, show how ready reception is and how ready security is for an external investigation, in terms of actually finding anything that is of concern, I think it risks giving false negatives and false positives. So you may find something and think it's amazing, and it may just turn out to be nothing, or you may get a sense of relaxation that you haven't found anything that is ill-founded. So that's my view. I think a properly done internal investigation is a good tool, and I think it's a useful tool, but you do have to use proper tools within it, such as key search words, etc. And an alternative to mock-dawn raids is just to train reception and security on what they need to do in the event of an external investigation, and then do your internal investigation properly. Finally, audits. Audit can be used in many senses. An audit could be done by internal audit, but obviously they're not best placed to identify legal issues. In my experience, an internal audit can be done by the lawyers, and perhaps we'll return in a later question to legal privilege. But I think there's nothing beats a good, properly conducted internal investigation. Oh, Joe, what are your views?
Joe, you're on mute.
Indeed, yes.
All right.
I share your concern about mock-dawn raids, particularly where they're not pre-announced or it's not disclosed that this is a test of some sort. And I also believe you're right, you can get false negatives, false positives. I'm a strong believer in doing compliance audits. Now, I know in the US, there is sometimes a tendency in antitrust to confuse the two concepts, audit and investigation. They're very different. An investigation is triggered by an allegation or a belief that there is something wrong. An audit is a review to see what people are doing. You're looking to see if there's improper conduct. And you're also testing your systems to make sure that they all work. And there's definitely a need for conducting audits. I would also say that in antitrust really has to be done by antitrust lawyers. And they also should be using the technology appropriately, so they should know how to analyze data and that type of thing. I'll add one other point about the types of reviews. Investigations, as indicated, are pointed, targeted. Audits are a more general review, but you can definitely find things in audits. And the third element is evaluation of the program, where you're looking to see if your program is actually working. And so, for example, you might combine audits and elements in an audit and evaluation, where during your audit, you might ask people, what do you remember from the antitrust training? And that gives you some input on how effective the training is. But as far as these dramatic mock dawn raids, I agree, that can just send the wrong message. And maybe the only result you do is to drive improper cartel conduct underground. And that's not something that you want to do.
Yeah. I mean, I would say that I've never made peace with the idea of a mock down raid. It has trended upward back in the day. Then I didn't use it either. Now a lot of people are voicing their concerns about it. But in my 24 years of private practice, I've never done a mock down raid. I've never allowed my law firm to do a mock down raid, also because of the risks associated with impersonating officials. And you're kind of losing the trust of the very people that you want to form a team with. And, maybe that you are detecting their reflexes in the face of a down raid type situation, but even that's doubtful, as Anne has said. So the benefits are really outweighed by all the disadvantages, I would say. So now a point that maybe the two of you might not agree on, and now that you've agreed so loudly and clearly on the distinctions between mock down raids and audits and internal investigations, and also I think we have sufficiently pushed around the idea of a mock down raid. What do you feel is the main point where the risk is brewing, or it needs to be tackled? So is the risk at the top, or is the risk in the middle? We always talk about tone at the top, not only in compliance for competition law, but also in compliance matters relating to anti-corruption issues and sanctions matters and policy violation matters. But is the tone at the top what is most critical? And most importantly, is the risk occurring at the top, or is it occurring in the middle, in the organigram of a company? Again, maybe Anne, if you would like to share your views, and then Joe.
Yeah, sure. Well, first of all, any good compliance efforts, whether you call it a program or whatever you choose to call it, but your efforts towards achieving antitrust compliance has to start with a really good risk assessment of where the antitrust or competition law risks are within the company. And that risk assessment has to look at the top of the tree, and it has to look all the way down. And you have to plot your risks, plan your risks, and design your program, or whatever word you like to use to call your compliance efforts, to meet those risks. So if you see some danger with your senior management, then it is important to address that. It is also important to make sure, vital to make sure that your senior management are on board, because they will not support you as internal significant resources and significant time, and requiring significant time from their staff and their middle and higher managers in terms of training or whatever way you want to get the message over. So I think, yes, you need to look at the risks at senior management level. I think you need to do everything you can to get them on board. And I always use a little catchphrase of my own, which I think I invented, which is never waste a good crisis. So if your company has a compliance crisis or compliance event, whether it's in antitrust or anti-bribery and corruption, anti-money laundering, whatever it might be, or even SEC reporting, as occurred to my company, then use that and make sure that senior management absolutely understand and buy in to all the compliance efforts that you plan to deploy. I know that many writers, academic writers, have said over many years that antitrust infringements often occur at senior management level. In my personal experience of my former company, that was not true. I think compliance incidents often occur at sort of middle management or even lower management level. And often it's because they may feel a bit of pressure from the top in order to deliver targets or whatever, but it's not, in my experience, driven by senior management. However, I think Joe probably has a different opinion.
Yes, well, I'll start off with the point about tone at the top. And indeed, there is quite a bit written about that. Unfortunately, in the corporate world, that's often translated into talk at the top, which may often mean the good old antitrust lawyer writes something and the CEO signs it, sometimes reading it, sometimes not reading it. That is not tone at the top, that's talk at the top. You have to look at what the top boss does and what the top management does. And so one easy example is when you're starting the antitrust training, is the CEO the first one to sign up? What does the CEO actually do? When the CEO is having a staff meeting and they're talking about a new venture, does the CEO chime in with, hey, make sure you check with Anne, our top-notch, brilliant antitrust lawyer, before you proceed? And in my experience, having spent 20 years inside, we didn't look so much to what the CEO said, we looked at what they did. And by the way, the most, at least back then, the most valuable source of what the CEO was actually doing was always the administrative staff in the executive suite. So word gets around if the top people do not really support the program, and they need to demonstrate that by their actions. People know what really counts in a company. With respect to the highest risk, we may not have so much of a difference in this point. I think that junior people in a company, if they're under pressure, may engage in improper conduct, cartel conduct. And sometimes general counsels don't understand actually how easy that is. I've had general counsel say, oh, we don't have to worry about our people, they can't set prices. You can commit an antitrust crime at a Starbucks with two of your competitors sitting around saying, you take the doctors, I'll take the lawyers. But here's the thing I've noticed. In those little cases, the government will never admit this, but I believe they actually don't care. They've got the big fish to fry, and that's what I go after. I was involved in a voluntary disclosure by one client that was very close to that latter point that I described, and the government thanked them for the disclosure, and that was it. Nothing ever came of it. And unfortunately, if you look at the record of the big cases, governments generally tend to go after the ones that are led by the senior people, and the senior people are in a unique position to pull these off. So it may be, if you're just doing a count, you're going to find more junior people involved in improper conduct. But when you look at where the risk is and where the government's going after people, it's at the top. And also, to Anne's very cogent point about too much pressure and driving people to engage in misconduct, that is also why when you read what the competition authorities say should be in a compliance program, they mention exactly that point. Are you looking at the incentive and motivational structure? Is it driving people to engage in misconduct?
Interesting. We have our first question from the audience. I can see that we're being viewed by 166 people. And Daniela Severin asks, after hello and thanks, on the issue of mockdown raids, wouldn't you have concerns regarding privacy rights of the employees as well? I don't want to, make you turn back to the whole discussion on mock raids, but I think it's a valid point, and I'd like to encourage more questions as well. So as questions come in, I will be introducing them immediately. Anne, would you like to take a stab at this question?
Yes, I absolutely agree about the data privacy, data protection issues. I think you need to be careful, and it would just, well, with any investigation, not just mock dawn raids, but if we just widen it out to other internal investigations and audits, I think you need a multidisciplinary team to help you do it. So you do need your data privacy experts to be there. You need your employment law experts to be there to make sure that your employees' employment rights are being respected and that they don't feel harassed or anything like that. You probably need other functions as well. You certainly need IT, without doubt. So yes, I think it's an excellent point on data privacy. And if you are doing an internal investigation or audit, make sure you get your internal team, the composition of your internal team right.
Yeah. Joe?
And I'd like to add to that the risks from privacy law, particularly GDPR, but all the other laws that are following that model, has so far been vastly underestimated.
Yeah.
Relatively speaking, it will be child's play for an employee to use the privacy laws to sabotage compliance program efforts and to interfere with investigations. Of course, a dawn raid is the ultimate, perhaps, but even a normal investigation where you're doing what you're supposed to do, dotting the I's, crossing the T's, you're going to get document requests, you're going to get requests to delete materials from the files, you're going to get objections that interview activities interfere with privacy. And when a company is looking at fines of the enormous magnitude that you can get under GDPR, and when you have privacy agencies looking specifically at how you're dealing with employees, it's just a setup for bad actors in companies to misuse those laws. Ultimately, what we needed was revision or an amendment to those laws, recognizing the importance of compliance programs. But for now, you need to pay quite a bit of attention to the privacy risks in this, in audits, in a full range of compliance activities, including running a speak up system.
Yeah. And one particular disadvantage of the mock down raids, in addition to everything that we've said so far, is also that it is easier for the employee to challenge the fruits of such a raid. So if the idea was also to collect evidence, a mock down raid is the worst tool to do that, because it's possible through a delicious technical discussion, it's possible for the employee to say that at the time of collection of all of this, the employee was under the impression that it's the state or public officials that are collecting it. Hence, his consent was one impacted by some form of duress. Whereas even if it's an unannounced audit, the company is representing itself as the company. The timing of it is not announced, but the company is exercising a compliance right. And so while trumping the consent of the employee, if need be, it is relying on its own right to do compliance work to the extent it's recognized in the given system. So a mock down raid could perhaps only be good for checking the reaction timing and politeness and what have you of the employees. But even there, I would take an exception, because once you do a mock down raid, actually you're risking the company with the notion that the real down raid may be confused with a mock down raid in the future as well. So you're teaching something to the employees that is really unhelpful. With that note, I'd like to turn our attention to what do in-house counsel want from outside counsel, which is promised in the title of today's gathering as well. And who better to address this point than Anne and Joe? Among them, they have many decades of in-house experience. And as in-house counsel, what would be the point where they believe outside counsel brings a particular added value? I'm not talking about the privilege issue yet, because we're going to take it on as a separate topic. but their understanding of the business, and overall, when do in-house counsel get disappointed with what they get from outside counsel, and what is a good outside counsel performance during a compliance program, be it internal investigation, be it compliance training. If you would like to talk about both of them, as you wish. Over to Anne again.
Okay. Oh, sorry. I have to say that I just got a message to say my internet connection is unstable. So if I freeze or disappear, please forgive me and carry on. Sure. I think a good external counsel, and there are many really excellent external counsel who can really help a company in its compliance efforts. I think a really good external counsel understands the company, understands the company's business thoroughly, and understands the company's strategic ambitions and intentions. Because there is nothing worse than external counsel coming in who are, I'm going to use an English slang expression, which is full of themselves, telling a company what to do when they really don't even understand the company. So if you want good external counsel, well, first of all, for antitrust, make sure they're antitrust experts. So don't get your property lawyer to come and talk to you about antitrust. And make sure that they thoroughly understand the nature of your business, the antitrust risks that your business faces. And I find, even though I'm slightly loath to say this, sometimes external counsel, particularly senior external counsel, can be very helpful in making senior management understand the risks that the company faces. And although they may have deep respect,
I think
external counsel who are... I've gone?
Sorry, I apologize, Anne. We lost you for a minute, but now you're back. So
okay.
Please do carry on.
Okay, so I don't like external counsel who are arrogant, and I don't like external counsel who assume that internal counsel don't understand the law.
Yeah, fair enough. Joe, what would be your take on good...
despite the fact you've been inside...
Sorry, Anne, I keep on interrupting you. It seems because of this connection problem that you have, our timings are a little bit off. I thought you were done. I apologize. Please go ahead.
I was just going to pass over to Joe and say, it made me smile when Joe said that he'd been inside for 20 years. I assume that you don't mean that you were inside the bars, but rather in-house. But anyway, Joe, from your experience, can you add to that? Challenge it?
I'll just add, I always avoid bars. I would expect outside counsel to know the company, as you indicated. And for example, if outside counsel is going to do training, I would expect the trainer to at least talk with some of the employees, talk with some of the attendees at the training, and find out what the company is about and what's going on. And the informal things, not what you read from the annual report, but really a feel for what the company is about and what employees are thinking. Anne mentioned the very important point of antitrust knowledge, substantive knowledge, and I absolutely agree. But when counsel is brought in to do compliance work, they're not brought in to do antitrust analysis. They're brought in to do compliance work. A lawyer should not practice in an area in which they are not competent. If the lawyer has not studied the field of compliance and ethics, they are not competent in that area. So a lawyer who's brought in to do compliance work should know the field of compliance and ethics, ideally should have experience in that field, needs to have expertise. Overall, we're talking about training, we're talking about investigations, but it's also important for outside counsel to understand that training and investigations do not make a compliance program. There's much more to having an effective program than that. And I mention these things because I've heard outside counsel speak this way, as if, yeah, the client needed a compliance program, so we went in and did training. No, that's not a compliance program. That's training. That's one portion of the program. I would also expect outside counsel to know what the relevant regulatory and enforcement agencies have said about compliance programs. And so if you're going to do antitrust training or an investigation in Spain, you should read what the Spanish Competition Commission has said specifically should be in a compliance program. So I would say, I would add to what Anne said, they need to know that part of the field. They need to know what compliance and ethics is about, as well as knowing the company. And when it comes to investigations, recognize you're not the police. You treat our people with respect. And I think that's also an important point. Having said all that, when I was in-house, I had the experience of working with some very effective, knowledgeable, respectful outside counsel.
There's also an inherent, I'm not going to call it a conflict, but a point of sensitivity, if you will, for external counsel, that you have to determine the depth of your dive into the internal investigation. And as external counsel, that always makes me a bit jittery. And that's where I'm particularly standing close to the in-house counsel instructing me, because ultimately, if you do it too wide and too deep, it has a monetary consequence of its own. You're using more attorney time. It's leading to larger bills. And, are you self-serving with expanding the investigation in a given way? And yet, if you keep it too shallow, it can turn into an exercise of just, putting your brand on an internal investigation and whitewashing something that will be found in the future. So the depth and the scope of the internal investigation is something that I find needs to be negotiated and discussed with the in-house, or between the in-house counsel and the outside counsel, quite carefully. I don't know if you would agree, Anne, that this is one of the areas where the in-house counsel would need to guide the external counsel so that it doesn't turn into an exercise of everyone parking their grief with the external counsel, and external counsel following up on all kinds of grief that is thrown at them, and the ability to focus on the true proceeds of the internal investigation is not lost.
Yes, I do agree with that. And I would go further and say that the external counsel, and most would do this anyway, will need to determine with internal counsel what milestones there are in any internal investigation or audit at which they're assisting, and maybe even negotiate fees for each step, and perhaps negotiate sort of contingencies if unexpected things turn up, so that it isn't just a sort of carte blanche for the external counsel to run off and create lots and lots of expenses and fees, but there's actually a properly managed and organised way of doing the internal investigation or audit. But I think there needs to be a real degree of trust between the external counsel and internal counsel. And as I've said, in my experience, there was a great deal of trust between external counsel. You need to have a distance as well, because it's important that the external counsel has to say, well, look, this is a problem and you need to understand it's a problem. Yeah. And I think the risk of whitewashing, if the external counsel is nothing but a puppet, is a real risk. So I think there needs to be understanding on both sides as to the proper role of each.
Yep.
Joe.
Yeah, and to come back to my theme of looking at this from the perspective of the compliance program, I agree with you. This is a delicate issue. You do not want the outside counsel going off on a frolic of their own, pursuing all kinds of things. But on the other hand, when they see any sign of an issue, any sign of any type of improper conduct, that should get to the compliance officer. And they should also report on any weaknesses they find in the compliance program And either they should perform or the compliance officer should perform a root cause analysis. It's not enough simply to find that some salesperson had a market allocation meeting at Starbucks. You should also be looking at why and how did that happen?
Yeah.
It's not that outside counsel needs to do that. It's not that outside counsel is best positioned to do that. But outside counsel in their report should identify that point and also should note in the report a need for follow-up. So whatever findings they have, they should emphasize that. My thinking is that message, yeah, it should go to your general counsel, but it absolutely needs to go to the compliance officer because they do have different remits.
Yeah. So on to the topic of legal privilege. Now, in my humble opinion, it is quite a disgrace that even the most sophisticated antitrust regimes around the world do not recognize legal privilege for in-house counsel. There is sufficient case law on this in the EU. There are jurisdictions that are following the lead of the EU as well, but other regimes also find that if you have included external counsel in the process in a given way, the correspondences that took place with the external counsel are privileged. However, the in-house counsel could be subject to discovery of evidence. And that obviously is also putting a weird moment of awkwardness into all this compliance program designs, because sometimes outside counsel is involved in these only to gain the legal privilege. I've had requests in my career where I was asked to send an attorney just as a note keeper to an interview that we didn't understand what the interview was about, so that because there is this note keeper, there's going to be legal privilege and all that, which I typically rejected. And said, there has to be one, this wouldn't be enough for there to be legal privilege. Two, there should be, a tighter nexus between our services and what you're trying to get at. So it cannot be that we're just being hired guns, basically, to provide legal privilege or to spray legal privilege over a given compliance program that is already done by in-house counsel. So, sorry for this long introduction, but Anne, how would you feel about where we are today on the matter of legal privilege and its impact on the compliance programs and internal investigations?
Yeah, well, I'm not sure that external counsel is really required to design the compliance program. They may give useful advice, and it's very useful if, as Joe said, they can identify problems with the compliance program so that they can be rectified and the program improved. But I think if you're doing an internal investigation in countries which don't have legal professional privilege for antitrust matters, and EU is obviously one main jurisdiction, although in the UK, which of course is no longer part of the EU due to Brexit, there's always been legal privilege in antitrust for in-house counsel giving antitrust advice, which is helpful. Of legal privilege, particularly in the EU, were really highlighted in a quite dramatic way by one of the cases that you mentioned, the AXO case, where the AXO in-house lawyers were actually doing a compliance audit and they were undertaking measures, and they even had a sort of an internal amnesty. And there are lots of issues with internal amnesties, apart from ones that would obviously come to mind, but they had run an internal amnesty to bring problems to the fore so that they could go and get leniency, whatever, and deal with the problem. And what these internal investigations, etc., there was a dawn raid, and these internal documents that were collated by the in-house lawyer were all collected and used against the company. So I think that's the case of, legal, a really good compliance ethos. Although I think AXO have done a brilliant job, by the way. But I don't think any lawyer in the EU likes the AXO case or the results of it. But I think in terms of the issue of privilege, just having an external lawyer is not going to give you legal privilege. It has to be instructions to them, be asking for advice, and you also have to be careful how widely, and well, at least in the UK under UK privilege laws, you need to be very careful how widely you distribute the results of any external advice, because if it's to too wide a group, then you will actually lose your legal privilege. So a really good discipline is to identify a list of people that you want to receive the privileged legal advice and keep it to that group, because otherwise, certainly in the UK and in other jurisdictions as well, by having it too wide, you can lose privilege.
Yep.
And certainly just by having somebody on the list who doesn't give an external counsel on the list who doesn't give advice is not going to give you privilege. Joe, could you give your view?
Yes, I think first, the denial of privilege for inside counsel is an example of form over substance. To say that all inside counsel are not independent and all outside counsel are independent just blinks reality. If you had a firm with 3 lawyers and they all did work for Shell, why would that firm be any more independent than Anne as inside counsel? Secondly, they miss a very important point. Inside counsel is typically more dedicated to the work, more focused on getting things done and getting results. Outside counsel can give the report and walk away. Inside counsel isn't going to do that. Inside counsel is the one who fights to make sure these things happen. What DG Comp has done and other governments who do this, they've sabotaged the role of inside counsel. They basically sent the signal to inside counsel, do not do sensitive compliance work, because all you'll be doing is gathering evidence for us to use against your company. In other words, we will make fools out of you for trying to do the right thing. I think that is a terrible policy. I think it is dysfunctional. And it's one of those things, have you ever heard the saying, fool me once, shame on you, fool me twice, shame on me? They, in the short term, were able to get the evidence in the AXO case. In the long term, they've harmed efforts to prevent and detect misconduct. I would also add that when people are doing reports, they need to be aware, even though the report may be done by counsel and you may think it's privileged, you still need to be very careful about what you write, and also to make sure that your report includes positive elements. And one other point I'd say about privilege, the ultimate solution for us in compliance is not privilege at all. It's a form of immunity for compliance work, because Anne's advice is exactly correct. You have to keep it confidential, which means you limit circulation. In the compliance field, it's exactly the opposite. You need to reach as many people as possible. Why superimpose a legal doctrine that is dysfunctional and limits the effectiveness of compliance? Better for the legal system to recognize that when we do compliance work, that is not something that's to be used against the company. It is something to be encouraged. So I think the approach of not recognizing privilege for inside counsel is an enormous policy mistake.
This is a nice segue into what I wanted to discuss next, which is yet another policy mistake, I believe, as far as compliance programs are concerned. And that is the fact that most regimes do not recognize a mitigating factor for a company that has a thorough, proper compliance program. The prevailing attitude toward compliance programs currently is that your reward as a company is the fact that you have managed to stay away from violation, hence risk, if your compliance program has worked. And if it didn't, it's not like we're going to congratulate you for a compliance program that didn't work. So you shouldn't be expecting a mitigating factor reduction in an administrative monetary fine or any sort of recognition of your efforts. Whereas I would believe that a proper policy preference about this topic would be that if it's not a sham, if it's a properly designed, well thought of, well executed compliance program, then regardless of its results, because you can always have rogue employees and incidents, the company would be a candidate to be encouraged and rewarded. This is a debate that I had quite a few times with different people. In a concurrence conference, I discussed this with Cecilio Madero, who was actually almost in favor of making it an aggravating factor. So he was thinking, if you have a compliance program and if you've still done it, then it shows intent. And with some others that were hesitant about recognizing a mitigating factor, like Frederick Ginny, for example. But I'm yet to find people passionate about recognizing a mitigating factor for complex compliance programs. And Joe, what are your feelings about this particular debate?
Okay, I missed part of the question because my internet connection's unstable again. But I think I got the gist of it from your last sentence, which is, what about recognizing compliance programs? I think the benefit of doing that can be seen from the anti-bribery and corruption world.
Exactly.
Where, the UK Ministry of Justice and the US FCPA enforcers have really gone to town in saying what their expectations are of adequate procedures, and the level of investment that companies put in to ABC compliance and other areas of compliance, data privacy being one, where compliance programs, good compliance programs, are recognised, has been really valuable. And I do believe, although the ICC has historically not been arguing for the recognition and credit given to compliance programs, I believe from my own personal experience that if you want companies to invest in compliance and to really put money and resources and management time into it, then actually providing some incentive for them to do so will actually incentivize them to put the resources where they should be. But I think if you want to speak to somebody passionate about supporting compliance mitigation, you really need to speak to Joe.
Yeah, thank you, Anne. And I might disagree with your opening characteristic about generally recognizing compliance programs being more disfavored. Actually, I think more and more DG Comp is becoming out of step. And for example, if you look at what the Spanish Competition Commission has done, it has moved in the opposite direction of recognizing programs. I commend to anyone what the Canadian Competition Bureau has done. And we've seen in its policy and its documentation on compliance programs. There's an irony here. The DG Comp issued a guidance on compliance programs called Compliance Matters. The irony is compliance doesn't matter to DG Comp. And the end result is that the enforcers lose all their leverage in getting companies to enhance their compliance programs. And there was an interesting piece a few years ago. There was an article written by two people in the antitrust division when at the time the division did not recognize compliance programs. And they noted that when they looked at companies, the anti-corruption compliance programs were gold-plated, they were great, and antitrust just got a few sentences. And they're wondering, well, why is this? Well, it's pretty simple. When you recognize something and treat people better for it, you get more of it. When you scorn something, you get less of it. And for the company management or general counsel who's trying to decide, where do I put my next element of resources. Do I do it where it matters to the government, or do I do it where the government scorns it? That's a fairly obvious decision in terms of which direction you could take. One other point I would make, which is a very common mistake, more in antitrust than in any other field, antitrust lawyers reduce this to a simple question: is your penalty reduced? I think that's wrong. I think it's fundamentally wrong. That's not the only point. The point here is that a company that tries not to break the rules is essentially a less culpable organization. No organization can prevent all misconduct. So if you're looking at the inherent guilt of an organization, if one company really has tried to prevent violations and the other hasn't cared and hasn't made any effort, the one that's tried is morally less culpable. And so therefore, the government should look at the entire range of options. And this varies among different legal jurisdictions. It could be a question of whether you bring a case, what charges you bring, who you charge, whether you go after a subsidiary or a parent. In other words, you're looking at a full range of steps you might take, because the effort put into a compliance program really tells you this company is a serious company, and there's really no benefit in penalizing this company. They're already doing what they can do to prevent misconduct.
That's very good. Thank you. Which nicely brings us to the topic of a holistic approach to compliance. I had written a book with two co-authors on the point of how do you secure a holistic approach to compliance in a company, and why it is quite awful to have a segregated regime, different silos and different people with different sets of eyes for different irregularities, and it never getting integrated, basically. So would you like to speak a little bit about why holistic? So I'm saying it this way because I know your views on this particular topic. Why a holistic approach is superior, and what does it mean to have a holistic approach to compliance matters, Anne? And
okay, and again, apologies, my internet is again unstable.
No problem. So the question is
I
the holistic approach.
I heard the question.
Yeah, you heard it.
I heard the question. Yeah. So I think a holistic approach is essential, because I think if you have different compliance officers or lawyers running around the company saying, no, listen to me, my subject's important, then you really risk compliance fatigue and compliance irritation, which is self-defeating. So I think it's essential that you get together with the other compliance disciplines within the organisation and work out a programme that works together. And, there aren't any silos, or shouldn't be any silos in compliance, because many compliance issues relate to each other. We've talked about data privacy, but the same is true of ABC, particularly ABC, because many ABC problems will give rise to antitrust concerns and vice versa. So if you don't have a holistic approach and you aren't joined up in your compliance function or your legal function, however you decide to organise yourself, then you are not, first of all, you are risking the failure, and secondly, you're risking missing issues that you should be identifying. And also, management have limited time, so you're better trying to focus the efforts in a way that really gains their attention and grabs their attention, and they go, oh yeah, I can see why this is important. I think I froze there for a minute, but I think you got what I was saying.
We heard you very
Joe.
fluently. No, we heard you very well.
And I think you're spot on. You need to avoid compliance fatigue. You can't have, I actually did a review in a company once, and the people in the plant looked up and said, oh no, another one? Safety had been there, internal audit had been there, some other area had been there. You just don't want that. to its credit, the OECD Working Group on Bribery issued a statement on compliance. It was called a good practice guidance. And right in the introduction, they make this very point that to strengthen the program, they didn't use the word holistic, but they basically said it needed to be integrated into the overall compliance program. To be effective, you need to have one chief ethics and compliance officer at the top of the program. Now, in each risk area, you may do separate things. You should, if you have an antitrust program, and every company should, you need somebody who knows antitrust. But you have so many common elements in a compliance program. You should have one speak up system, for example. You may have one schedule for audits. You may have one standard for discipline. You have one code of conduct. You need to pull these things together so you take one approach. Another point, which I think Anne touched on, is what I would describe as access to power. If you have 6 compliance officers, trust me on this, they're not, all 6 of them are not going to get 15 minutes at the next board meeting. It's not going to happen. So if you have one strong executive level compliance officer, that person can look and say, wait, I know the environmental people want to do a report and they'll get their turn, but right now there's a major antitrust issue that needs board level review and action. And so to have somebody who's fully empowered, they need to be at the top of that compliance pyramid, and they need to be in a position where they can effectively use resources. So for example, instead of 2 separate reviews of the same office, one for antitrust and one for corruption, you coordinate it so that you are covering all the points at the same time. So rather than having a battle of compliance forces, having it in one program with a senior compliance and ethics officer really is essential, I believe, to be effective.
Perfect, thank you. So one remark from Tim Cowan, he had asked this in the form of a question before we engaged in this discussion about holistic handling, but I think the rest of the audience would benefit from hearing. So he was saying, how are we going to make sure that the antitrust compliance policy is going to fit together with other internal systems of risk assessment and control? For example, is it a good approach to integrate them with Sarbanes-Oxley or other public company reporting obligations? So these topics of keeping it integrated and unified do come up very frequently, and this is also a very good example of that concern. The last topic is, I'm saying it is the last topic because we have 5 minutes to go in our time, is the issue of how to make sure that the compliance program is one of merits, that it addresses substantive issues, that it's not a cosmetic thing, or it's not handling appearances. A good example of it is something that I always reject for all of my clients, where there is this functionality that people sell, where you have buzzwords, and when employees are writing certain email messages, suddenly those buzzwords are, kicking alarms, and the employee then thinks of another word to use and all that. This is purely cosmetics. The employee learns nothing from it. If anything, it's just teaching the employee to conceal something. So in the compliance trainings and in the compliance programs in a broader sense, how do we secure that what we do is for substance to actually make a difference, and it's not only to manage appearances? Over to Anne on this.
I hope you can hear me.
We can.
First of all, I agree with you. I always resisted and would continue to resist requests of words that should be avoided. 2 reasons. One, because it risks merely hiding bad behaviour or even encouraging bad behaviour, which is worse. And the second reason is that, I have seen cases, or not necessarily in Shell, but in-house counsel have mentioned them to me, where the first thing that the agency has picked up is the list of words that shouldn't be used and the alternatives. So don't do that. It doesn't help. It's not going to achieve real compliance. The message should be about doing things. It should be about doing business with integrity. And so I think a company that is and act with integrity, you can feed on that message and say, look, it's not just doing the right thing in right words, it's actually doing the right thing. So I think business integrity and a commitment to business integrity is a good platform for compliance officers and compliance legal advisors to use to help the company understand that lists of words don't help and actually can really harm the company.
Yep, thank you. Joe, your take on this?
Yeah, I'll start with a point. Sometimes people talk about their antitrust policy. A policy is a piece of paper. It is worthless. It does nothing. It is a tool. We should always talk about a compliance program, not the policy. The policy isn't going to do anything. With respect to how you make sure the program is not cosmetic, I want to go to something that the Antitrust Division in the US said in its list of questions, and something I've heard the Canadian Competition Bureau also buy into. They're not waiting for you to bring a stack of papers to show them how much paper you have in your compliance program. They're going to be talking to your people at the beginning of the investigation, all throughout the investigation. If your program is a paper program, trust me on this, your employees are going to know. And when they're asked about the compliance program, they're going to say, what compliance program? Or, oh, that's just a bunch of paper. My boss told me it doesn't mean anything. They're going to pick that up pretty fast. And so for me, if you want to make sure your program isn't cosmetic, it's a real simple point. Talk to your people. They will know. If you're not reaching your people, your program is a flop. It's a failure. If your people say, yeah, I had the training and I thought it was pretty good. I remember one of the points that Anne made, that she said, we shouldn't do this and we shouldn't do that. And boy, 2 weeks after that training, our supervisor came in to us and said, you remember that training we had 2 weeks ago? Here's some points I want you to remember. Those are the types of things that make programs effective. It is not rocket science to test it. In fact, I'll give you an example of one evaluation I heard of from an enforcer in the US named Jim Sheehan. He'd been called into a company to evaluate their compliance program. They're trying to convince him not to prosecute. They had him in their headquarters in a conference room. He asked if he could take a break and go to the restroom. On the way to the restroom, he just stopped random employees and asked them about their code of conduct and their compliance program. They all looked at him like he was from Mars, and they said, what code of conduct? He said by the time he got back, he knew everything he needed to know about their compliance program. So my point is, it's just not that hard to figure out if a program is cosmetic. Your people will know. When you talk with your people, see what they tell you about the program. And to Anne's point, you really have to be serious about the program. And it needs to be built not just on technical, here's what the law is, but on company values and having an ethical company and an ethical approach.
Thank you. This is really very much appreciated. It was wonderful to have access to both of your insights, your wisdom. Harveen, over to you. I think we're done as far as our time is concerned, and also the prep conversations that we had yielded these particular topics. So I think we've done well in covering all of them. Over to you, Harvey.
Yeah, you've definitely covered a lot of content there. And thank you, Anne and Joe, for taking time out of your busy schedules to share your expertise at this webinar. A special thanks to Ganance for hosting such an insightful discussion. I know many of our viewers would love to maybe revisit parts of some of the topics that were discussed. The webinar will be uploaded to our on-demand service, so you can find that up there in a couple of days. Thank you everyone for attending, and enjoy the rest of your day.
Thank you.
Goodbye.